337 and 342 of PMLA. So basically, the brief of the complaint is that the complainant has alleged that some person identified themselves as police officer have digitally arrested them and treated them for an amount of 97,000. My role was not initially, my name was not initially named in the FIR. I was being arraigned as an accused on the basis of a statement of the co-accused. Number two, on a side. My submission is that no amount has been withdrawn from my account, Your Honor. There has been no misappropriation of funds from my account, or there is no flow in and out of any amount of the LS by the complaint in my account, Your Honor. I even don't know the accused number one was the Tanvir. There is a statement made by Side. Now, on the basis of that statement, I have been arraigned as an accused, Your Honor. I am 21 years old. I'm not involved in this offense, Your Honor. I have been previously arraigned as an accused in another FIR in Baroda, but in that case, I'm enlarged on bail. And I've also moved an application for caution with the Honorable High Court. But the Honorable High Court has been pleased to issue notice, Your Honor. I am involved in this offense. There is no misappropriation of funds by from my account, Your Honor. I'm 21 years old. I have responsibility of my family. My father is only the only person who is doing jobs. There is my father, mother, and sister who is responsibility of me, Your Honor. If I'm being enlarged on bail, Your Honor, I'll be bound by the any conditions laid down by the Honorable Court. Now, if the Honorable Court is inclined to grant me bail, I'm also willing. It is not an ambition on my part, but I'm also willing to deposit the same amount of the alleged amount in the FIR of 97,000 before the Honorable Court as well. It's not an ambition on my part, but this is the only bona fide. Just because I'm no one related to this offense, I've been wrongfully behind the bars, Your Honor. It is my humble submission to grant me regular bail.
You are the person who was in contact with the end user from the start.
So, Your Honor, I don't know.
The person bail is rejected.
Yes.
Now you contacted that, you facilitated the bail transaction, and then you are also in contact with other people who fraudulently make transactions. Get that amount deposited in the account. You are the mediator for those people, Chinese people.
No, but please, Your Honor, but I'm nowhere related to this offense of the alleged by the complaint regarding this FIR, Your Honor. I'm not aware about the transactions done with the complaint.
You are the only person who is in contact with those persons. Direct.
I may be in contact with some other persons, but I don't know. I'm nowhere involved in this digital arrest done by some alleged persons in the FIR.
After digital arrest, they wanted some accounts in India to be operated so that money goes in that account and then immediately get transferred to the Chinese account, and then Chinese people they will do some other transaction.
But the amount which was transferred to the account was of Tanvir, which was rented to Sahil. It was not rented to me.
So that your instance, convenience Sahil for involved, it's your instance.
It was a statement of the co-accused, but it is nowhere in the record, Your Honor, that the amount was being misappropriated by me, Your Honor. It was been misappropriated by Tanvir and Sahil, and the account was of Tanvir, which was been rented by Sahil. So there is no transaction in my account, or I haven't used or misappropriated that fund which has been transferred from complainant. But I am just 21 years old and
You created fake police, you created fake case, you created fake advocate, What defend your fake case? You arrange everything except fake vote.
You know, I'm
You means you people hold on to.
I even don't know this person, Your Honor. I don't know who is doing that.
Online code, online fraudsters.
I may be involved in some other transactions, but there is no connection of my with these transactions which has been alleged by the complainant. I even don't know who is Sunil Dutt, who has been identified as a fake police officer, who has been identified as a fake advocate. Just because merely upon the statements of the Sahil, who is another person co-accused, regarding some another transaction, some another WhatsApp history or Telegram history
Why
conversation.
were you in contact with those two of this person?
Please, no?
Why were you in contact with those two other two of this person?
Yeah, I was not in contact with any of
All detail.
I was only in contact with Sahil.
For what reason?
Some other transactions which may not be unlawfully illegal right now, as per my instructions, Your Honor.
You are deciding it. The two of you whose bank account are being taken on well. They belong to that. What relations to you?
Well, the time listening in Ahmedabad.
Ahmedabad.
I'm 21 years old. My life will be going because of this. I'm bona fidely I'm ready and willing to deposit the same amount before the amount.
We don't know what amount, how many transaction would you have done.
As per the say of the complaint, as per this FIR.
It is no grounds, once you commit the offense, then,
I understand, Your Honor, but it is just a bona fide gesture from my side.
then you say, I am bona fide, I will deposit.
I'm ready and willing to burn by any other condition placed by the honorable court. I'm ready and willing to deposit my passport.
This should be investigated to prevent this kind of, fraud.
I'll not be living. Ahmedabad itself.
You don't need to move anything, you don't need to move even from your room also, when you are involved in, cyber crime.
No, but I'm not involved in this any of it like your digital arrest, Your Honor. And maybe there may be
Some
some.
might not permit other person to even, move from the room. By digitally arresting.
It is my submission that I am not involved in the digital arrest offense, Your Honor.
Because this, online fraudster, you facilitated them.
No, Your Honor. So I've not facilitated any of
You
you.
facilitated that whatever amount comes, it will be deposited in the account of Sahil and they turn you. In one account is open, take on rent, paid some amount. Other person withdraws, take away the whole, the detail of the account, there is transfer in some other accounts and from that account it is, transferred in another, in digital currency.
My lord, I'm not aware that these transactions of any of the transactions are related to any of the digital arrest with complaint or any other person.
Then who's there? Why this money, complain and send in the account?
That is my submission, sir. Your Honor. I don't know what transactions have been done by Sahil or Tanvir. I'm just involved in some another transactions or another checks, conversations with Sahil, which have been taken on record and I have been arraigned as an accused. It's merely upon the statement of Sahil.
નાણા ગયા તનવીર ના ખાતામાં તનવીર અને મહેબૂબ સાહિલ મહેબૂબ બંને જણાએ કેસ ઉપાડ્યા અને કેસ ઉપાડીને પ્રિન્સ અને જમીનગીરીને આપ્યા રોકડા અને એ પૈસા પછી યુએસડીટીમાંથી ચાઇનીઝ એકાઉન્ટમાં ગયેલા છે.
But still there is no evidence that we have withdrawn that amount or been deposited.
સાહેબ એવું જણાવે છે કે 7% વ્યાજ આપવાનું જણાવ્યું નીચે લખેલું સાહેબ આફ્ટર 2 લાઇન્સ 7% વાર્ષિક સાહેબ જે 1500 રૂપિયા મળે છે ને 50,000 ના એ પ્રમાણે જોવા જઈએ સાહેબ વાર્ષિક 36% વ્યાજ મળતું હતું સાહેબ મતલબ જે કીધું છે એનાથી વધારે મળતું હતું ઓછું નથી મળતું પહેલી વસ્તુ સાહેબ એ વ્યાજ સાહેબ મળ્યું છે ક્યાં સુધી 11મા મહિનાની 5 તારીખ સુધી મળ્યું સત્ય
para 15, sir. Coming back to the section 3 of the PMLA, on its plain reading, an offence under section 3 can be committed after a schedule offence is committed. Now there is no schedule offence against me, sir. This is a on record. Now, sir, for example, let us took care of a person who is unconnected with the schedule offence, knowingly assists the concealment of the proceed of crime, or knowingly assists the use of proceed of crime. Use of proceed of crime. So there is no, I'm not know that this money is trail. That money is trail. That money is used in the proceed of crime, because I am not connected with the approach patta. Now, sir, relevant. In that case, he can be held guilty of committed an offence under section 3 of the PMLA. To give a concrete example, the offence under this 384 to 389 of the IPC related to extortion are schedule offence, including in para 1 of the schedule of the PMLA. An accused may committed a crime of extortion covered by, say the example of 384 and 389 IPC, and extort the money. Subsequently, a person unconnected with the offence of extortion may assist the said accused in the concealment of the procedure of extortion. In such a case, the person who assists the accused in the scheduled offence for concealing the procedure of the crime of extortion can be guilty of the offence of money laundering. Therefore, it is not necessary that a person against whom the offence under section 3 of the PMLA is alleged must have been shown as accused in the scheduled offence. What is held in para 270 of the decision of this court in the case of Vijay Madan Lal Chaudhary support the above conclusion. The condition precedent for attracting the offence under section 3 of the PMLA are that there must be a scheduled offence and there must be proceed of crime in relation to the scheduled offence defined in section so and so, so and so. Now, sir, first contention, I am not involved in the scheduled offence. Second thing, sir, there is no money trail, sir. As per the judgment of the Supreme Court in para 65. Now I read the para 65. Because there is no property attached or obtained directly or indirectly, sir. Prosecution showed when money trail, it is in my account and I forwarded in another account. I am as a business last 30 or 40 years for check exchequer. Check discount, sir. So I am not as per the para 15, I am knowingly active. I am not knowingly active. Apone pelu. Para 65 put the page up. Para 65 se read karu chu with your permission. And page number sir 316 judgment. As aforesaid, in this backdrop, the Amendment Act 2 of 2013 came into being, considering the purpose of amendment provision and experience of implementing an enforcement agency. Further changes become necessary to strengthen the mechanism regarding the prevention of money laundering. It is not right in assuming that the attachment of property provision under the second proviso as amended has no link with the scheduled offence. Section 5, sir. In as much as Section 5 bracket 1 and NY says that such an action can be initiated only the basis of material in possession of the authorized officer inactive of any person being the possession of proceed of crime. The precondition of being proceed of crime is that the property has been derived or obtained directly or indirectly. So there is no attachment against me, sir, under Section 5 of the PMLA Act. So prima facie, there is no offence against me, sir. Prima facie, sir. They show me that money to trail, and I use that money as a proceed of crime. I am obliged, sir.
Last option I have given to the judgment. એમાં કદાચ આ પણ જજમેન્ટ છે આપણે બે જજમેન્ટ થઈ સર એને ગઈ વખતે બે જજમેન્ટ સાહેબના મેનેજરમાં છે. સાહેબ આ જજમેન્ટ જે છે પહેલા 17 અને 18 છે. સાહેબ મેં ગયા વખત આપણે બધી એફિડેવિટ બતાવી દીધા કે crores of rupees have been actually. જી સર. ના ના હું કહું છું અને એફિડેવિટમાં સાહેબ the role of the accused has been activated on error.
બધામાં સરખી સર 229 સેમ યસ સર ચેક ડિસ્કાઉન્ટ યસ સર
લગભગ સર ટ્રાન્ઝેક્શન સિમિલર છે પણ એમાઉન્ટ સુધી જાય અને કંપનીઓ બદલાય. પ્રવીણ કુમાર જૈન. પંકજ ઠક્કર. બહુ સરસ. એમાં સાહેબ પહેલા 9 page 4 the accused Pankaj P. Thakkar, Mr. Jalaram, there are 9 page 4 affidavit. Yes, sir. Which is engaged in check discounting of crores of cross check, third party payment and RTGS transfer had effected RTGS transfer to the companies namely Mr. Just Trader, Arju Enterprise, Mr. Pramda and Company and GC Traders on the direction of C. Sagar and C. Dharmendra Choksi of Mumbai and C. Aushalsa of Ahmedabad. The Sagar and Dharmendra Choksi were crops based in Mumbai and they would send cash to Angadia and the Aushalsa of Revdi Bazaar, Ahmedabad would come to accused office with check and directed him to RTGS transfer to the fund mentioned above. The amount of commission received by Mr. Jalaram India Limited varied from 5,000 to 7,000 for 1 crore transfer. Therefore, accused are knowingly involved in such process and activity connected with the proceeds of crime, including its process, including its possession. He was instructed in transferring the cash received by him in various funds like Mr. Just Trader, Arju, Pandna, GG Trader, for RTGS. The funds received by Mr. Just Traders and so were eventually remitted to of India against the bill entry. It is denied that there is no evidence with regard to requisite knowledge of the part of the accused and his involvement of money laundering. The various acts of the petitioner in routing the funds to firm having no genuine business activity. The act of not maintaining record of this transaction in that no agreement were made. All points out of the fact that the accused was very much aware of the entire racket as he is closely associated with one of the mastermind, Afroz Muhammad Hassan Bhatta and Madanlal Jain, both are the main actors. In this regard, the call data record collected by PCB Surat during the course of their investigation and referred to by them in their supplementary charges data 15/14 filed by them against Afroz Hassan Bhatta and Bilal Harun Gilani will be relevant to consider by the special court, PMLA Ahmedabad, as the charges filed by the police have already been committed to special court PMLA from the court of Chief Judicial Magistrate Surat, filed order dated 15/9/17 and term of section 44. PML. the complaint had filed certain annexure of documents with the prosecution complaint to bring to notice of this honorable court that the accused was aware of the knowledge of commission of the offence. The accused has made payment to various entities with whom he had no business transaction, and this in itself shows the involvement of the petitioner. As he has chosen to knowingly involve himself with these dubious entities. Evidence is that they have received the cash amount, crores of rupees, and they have transferred made RTGS to their bank to fictitious form, which are not in actually their namesake existent. And at present, when the service of the summons of this honorable court was issued, they are not available, sir. And they are not, no company is found at the relevant address. They have transferred the money. That amount has been actually remitted to the bank by these different firms for the purpose of transferring that money to the out of India banks. એમાં સર આપણે કહું કે એ લોકો શું કર્યું બોગસ ઇમ્પોર્ટ બતાવ્યું સાહેબ ડાયમંડનું, અને એ ડાયમંડના ઇમ્પોર્ટના જે પેમેન્ટ જે કરવાનું હતું આ બધી બેંકો થ્રુ આ બધી ફોર્મ થ્રુ બેંકોમાં જમા કરાય, બેંકો થ્રુ પછી એ ફોરેન કન્ટ્રીઝમાં હોંગકોંગ અને દુબઈ ટ્રાન્સફર થયા છે 5,500 કરોડ ઉપર. હા એટલે મની ટોટલ આટલા એના કિસ્સામાં સાહેબ they used to take the commission 5,000 થી 7,000. આ જે કેશ પૈસા જેના નામે પેમેન્ટ કરતા હતા અથવા જે માણસ કેશ પૈસા આપતો છે, હા એની પાસે રોકડા પૈસા આવે ને એ સાહેબ આ બોમ્બે થી આવતા હતા, એટલે જુદી જુદી પાર્ટીઓ નામ હતા સાહેબ એમાં એ કહું ચલાવ એ જે કેસ આવતો હતા ને એ અફરોઝ પટ્ટા અને મદનલાલ જૈન. એમની જરા ત્રણ નંબર લોકો બધા કેશ કલેક્ટ કરે આ મદનલાલ જૈનના કોઈ પણ માણસો, અને એ કેશ એમાઉન્ટ જે છે એ આરટીજીએસ થી આ જુદી જુદી ફોર્મના નામે ટ્રાન્સફર થાય એના એકાઉન્ટ. એ આરટીજીએસ એ પછી બેંકમાં ટ્રાન્સફર કરે એમની રેલેવન્ટ બેંક. હા હા પોતાની બેંકમાં જમા કરે અને આરટીજીએસ કરે. ये आर्टिकल आप जुदी जुदी फॉर्म से ना डिफरेंट कंपनी અને એ કંપની ફોરેન કન્ટ્રીમાં ટ્રાન્સફર કરવા માટે ખાલી આના પૂરતા જ આમનો ઉપયોગ છે સર. આ ટ્રાન્ઝેક્શન પૂરતો છે. or transfer the money. Yes. हाँ हो सर ये भी सर बात आप लगभग और एक तो आरजू एक into various from back just as a check પછી આરજુ enterprise. Yes sir. Yes. 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 કયા એક્વિઝિટ કઈ કંપનીમાં ટ્રાન્સફર કર્યા યસ એમાં સાહેબ પેલો બનાવેલું છે વી મેડ એ ટેબલ સર નો ટોટલ યસ this amount is the 5,395 crore rupees. આમાં સાહેબ અમુક જે ફોર્મમાં એ લોકો પૈસા ટ્રાન્સફર કર્યા એ પૈસા આ ફોર્મો જે હતી એ લોકો બીજી ફોર્મમાં પણ ટ્રાન્સફર કર્યા છે પેરા નંબર 6 માં સાહેબ પેરા 6 of my replies. The investigation revealed that the above mentioned Indian entities had received the above said amount through RTGS credit in their respective bank account with ICICI Bank primarily from certain other Indian firms, namely Messrs. Vanna, Nature Trading, Maruti Trading, Millennium, Arju, GT, MD Enterprise, Just Trading, etc., which had transferred the above said amount from their accounts with Axis Bank held in Mumbai and Surat. These firms in turn had received RTGS credit into their bank account from various other firms based in New Delhi, Mumbai and Surat. Yes, sir. Individual form I will preparation. How much amount they have done? And sir, modus operandi is what? Yes, sir. This purpose of transferring the money to foreign countries for the purpose of actually smuggling activity, so that they can use that money for actually purchasing gold and other things to be smuggled into India. આમાં આ પૈસા જે ફોરેન કન્ટ્રીમાં ગયા બેન્કિંગ ચાર્જથી એ પૈસા પાછા ઇન્ડિયામાં કેવી રીતે આવતા હતા તો દે યુઝ ટુ પરચેસ કોમોડિટી અને બાય વે ઓફ સ્મગલિંગ ધ that amount was utilized for the purpose of smuggling actually. Yes. આજે પણ મારા આવ્યો એટલે એમાં શું છે કે જે સુરતના જે નવા એલસી આવ્યા છે ને સી ઇઝ અ ન્યૂ લેડી એટલે જસ્ટ આઈ હેવ ટુ એટલે મને અઠવાડિયાનો ટાઈમ આપું સર યસ સર ના ફોર પ્રિપેરિંગ ધ ચાર્ટ ઓનલી યસ સર so much બહુ ટાઈમ થઈ ગયો સાહેબ આમાં આ બે જ હતી યસ આ બે જજમેન્ટ છે સાહેબ એમાં જસ્ટ આઈ એકચ્યુઅલી વિજય મદનલાલ બીજું આજ એમને જે બતાવ્યું એમાં પહેલા નંબર 16 માં જોશો સાહેબ તો એમાં there should be actually procedure crime and attachment not from the same person attached from anyone money might have transferred he has assisted in transferring the money
Yes, sir. Here assistant. They don't consider the very offense.
Para actually,
You say that, here assistant.
assistant, मतलब, they have actually dealt with the proceeds of crime, sir.
They have helped it. It's very important.
Yes.
Here assistant, I would assume if I am getting something. How? Yes, discount. Because here, 8 crore money has been discounted. Or they have. Assistant work, money, assistant. Trade of, proceed of.
Yes.
crime, that would be the-
Yes, that amount was received in cash, sir, first thing. It was not through any proper channel. There is no accounting.
For that separate aids are there.
Yes, sir.
So very basic incident would be knowledge.
Yes,
And their indulgence, directly or indirectly, we have a system will go exactly.
no, implied knowledge, because huge amount has been actually obtained in cash. And
They can charge to other. What is this case? If a person. The current situation is, there is one for. There's fixed. Ask only procedure, then they can be moved for other. Maybe actually with the other. But as far as definition, it is about very.
yes, sir. And knowingly what can be interpreted by the act of the accused, sir.
Otherwise, it may have proceed of crime and travel to number of person.
Yes,
That amount of person.
because it was not legal acting. That is true. Yes, sir. Yes, sir.
Otherwise, you may receive fee from it. It won't legally receive by it.
Yes, sir. આમાં સાહેબ આ બાબતે ક્લેરિટી yes,
I have gone through the journey. I have gone through the journey. The body,
knowingly સાહેબ
its involvement in the offense should be not clear on the basis of our assumption.
એટલે સાહેબ presumption drop કરે ને આમાં section 3 માં the person who dealt with knowingly word use કર્યો છે but knowingly સાહેબ એના માટે direct evidence તો હોય જ ને circumstantial evidence can be considered, sir.
If someone is, if a person is selling, take it against of the speaker. Now, he gets some less money in first of the weekend. Now, you or I purchase a flat from the.
Yes.
So that I was thinking, okay, we have designated property which is constructed by the speaker who might use the money. And
But if I have received that money directly or indirectly, sir, construction, I am purchasing the, yes, sir.
there is a property.
Yes,
What would the right of the person who is purchasing from his own right?
yes, sir.
Would also that no one knows whether the bidder has taken loan, whether it is legal or illegal money. Let's take example, you receive a fee, where receive the fee from his client. It is less than. And you are also dealt with that money. What is going to be happening?
Knowingly what, yes. But આમાં સાહેબ knowingly,
Then you have to point out that what I am.
yes, sir.
I'm just giving example.
Yeah, I understand.
Everyone would be booked with money laundering.
But here they are the actually dealing in day-to-day basis, sir. And collecting cash,
Day to day, it is then business.
this is not a legal business. This is not legal business.
But that does not affect PMLA.
Because the same money which has been actually generated through criminal activity has been used by them.
Here there is one person who is involved in criminal activity of crime. His money comes to me, then I am automatically happy to automatically.
Yes. હું સાહેબ એના માટે આપને જો સાહેબ પોઈન્ટ આઉટ એવિડન્સમાં તો સાહેબ આ છે on the honorable court has to inform from the events which has been taken place. There is no account, sir. First thing. Secondly, huge amount has been used. આના સાહેબ કોઈ document evidence જ નથી. They do not prepare any actually ledger or some anything. Yes, sir. Yes. Yes.
And they will go into the petrol and then money will never go anywhere.
Yes.
Now they deposit, that amount is in vain. They is transferring to other different companies.
Yeah.
From where it has gone to, outer. That is the very basic problem. You can't say there is no problem.
The bank account which has been used by the accused is for the purpose of money laundering, sir.
Oh, they are no particular.
No, this accused also, sir. They have used this bank account and this bank account is being used for the purpose of money laundering, sir. No. Yeah. No, they might be dealing with so many persons. But so far as this amount is concerned, they ought to ask that what is the purpose of depositing so much cash amount.
Okay, yeah, when you customer did not ask to anyone in this mode, and neither IT income tax asked to anyone. Why would that person bring business to say, and I have to you say they don't do business. But you don't have that authority, like you or other department.
But this business is
It's opposite.
even, sorry, the tax discounting is a different thing. Sir. Cash amount is to be making wide and transferring, sir.
You might be right. The general BMP has that.
Yes, sir.
But our inflation can't be a ground to the.
Yes.
That is which are with your created case. It should be on the basis of evidence collected by.
Yes.
By this time you have to point out that you are going legal. Therefore, the wording is not so direct, it's also indirect.
Indirect.
Going is definitely there.
The knowledge cannot be actually brought on record from any direct evidences. The knowledge can be actually inferred from the event which has taken place. Yes.
Now, how is it?
This circumstance, huge cash amount transferring in the account of the funds which are not in existence for the purpose of this. Yes,
So is more than actually.
yes,
There is no attachment from him.
yes,
So now. The basis he section 3. This knowledge. Here is there. Directly or maybe indirectly. You are going to use that here. Taken the get money, deposit in the bank account, then transfer to other account. What is it? You have to point out that money trail for this. So, this is the knowledge. So, effect section 3.
yes,
You give a start.
yes.
Now, this one. From all the town, you are also relying on this.
Conclusion para 27E. Conclusion para 27E. The offence punishable under section 120B of the IPC will become a scheduled offence only if the conspiracy eligible of committing an offence which is specifically included in the scheduled offence. If I conspired with the main accused, why I am not added in the scheduled offence, sir? Naturally, sir.
This is
So
the-
many interpretations
on the point of schedule
of
offence,
this para, sir. No doubt.
this is for the purpose of actually imputing
Right, sir.
120B. Yes,
And there is no offense against me, even IT Act even, sir. Your honor is already raised the query, sir. No, sir, discussion, sir. So when so many huge amount is I remitted to other account. Why offense not against me, sir, in IT Act even, sir?
We'll decide why money don't pay.
Yes.